Good morning, everybody, and welcome to our HRLaw webinar, which wraps up what has been an extremely busy 6 months in the employment law world. I'm Jo Chatterton, a partner and head of the employment and immigration team here at Fox Williams. As many of you know, we have grown our team quite substantially in the last few months, and I'm delighted to introduce this morning two of our new colleagues, partner David Williams and legal director Justin Terry, who will be covering some of the topics that we're discussing. We are also delighted to end the year with news that we've been shortlisted for the Chambers and Partners Employment Team of the Year Award, and the feedback that we have from clients is a part of that selection process. So thank you to all of you who've contributed. Just a few admin points before we start. The webinar is going to be recorded and it will be made available to those who've registered but can't join us this morning. And we are happy to take questions on the topics under discussion today. So if you could put these please into the Q&A box rather than the chat box, we'll aim to cover as many of these in the time that we have available at the end of the session. So I wanted to start first with a question for you and a small poll. So if we could pop the poll up on the screen, please. The question we have is, what do you think is likely to be the most challenging change for your business under the new reforms? If you could select your answer, and we'll see what the results are, and then we're going to repeat this at the end and see if your answers are the same, having heard the speakers this morning. Just give you a few moments to click the boxes and have a think about your answers. Okay, Bailey, could we put up the answers, please? Here we go. So perhaps unsurprisingly, I think unfair dismissal, day one right, is the thing that is concerning you most. Okay, so we'll see, as I said, what that looks like at the end of the session. So in terms of what we're going to cover today, firstly, I'm going to be discussing effective steps to defend allegations that the new duty to prevent sexual harassment in the workplace has been breached. Justin is going to be discussing the forthcoming employment law reforms with a focus on those day rights, which we know you're all very concerned about. And then David is going to move on to discuss what the bill says about fire and rehire, collective consultation and changes to trade union recognition, the latter perhaps being something that many of the audience today may not have had to engage with previously, which you may well need to do in the future. So we can't discuss the entire volume of the proposed employment law reforms this morning because they are pretty extensive, but we'll be covering other topics and closely tracking the bill and all the proposals through our regular HRLaw email updates and obviously in future webinars. And trying to give you practical guidance about compliance along the way. So if you've not subscribed to those updates, please do let your usual Fox Williams contact know, or indeed email me, and we can get you and any members of your team signed up. Okay, so let's get started then with looking at how you can meet your new duty to prevent sexual harassment in the workplace. So just a very quick recap to start with. This is a proactive employer duty to prevent sexual harassment, which came into force on the 26th of October. And the duty is to take reasonable steps to prevent the sexual harassment of employees in the course of their employment. And this is an anticipatory duty, so it requires employers to anticipate scenarios when its workers might be subject to sexual harassment and to take reasonable steps to prevent that harassment taking place. Now, the new duty doesn't give rise to a standalone claim against the employer. It works like the failure to follow the ACAS code of practice when you're carrying out disciplinary or grievance processes. If a claimant is successful, the employment tribunal can uplift the award made by up to 25% if it believes the employer didn't take reasonable steps to prevent the harassment occurring. And that uplift can apply both to compensatory awards, which of course for discrimination are uncapped, and also to injury to feelings awards, because sometimes people bring claims when they're in employment and haven't suffered a financial loss, but have suffered an injury to feelings. So the big burning question is which we will focus on this morning, is what are the reasonable steps and how can you demonstrate that you have taken them? Could I have the next slide, please? So the first thing to say is that there is no one-size-fits-all checklist of steps that you should take, unfortunately. The assessment of what is reasonable is going to be employer-specific. So the size of your organisation, the sector you work in, the nature of the business you carry out, the working environment, where your employees carry out their work, and the nature of their interactions with others in the course of their work are all going to be relevant to the question of what is reasonable for your business. I think larger employers with better resources are probably expected to do more, as might a business in a high-risk environment. So, for example, if you're an organisation supplying staff to work at Christmas parties or events. Now, the starting point really is two key documents which you really need to be able to say that you've read and considered, which are the Equality and Human Rights Commission's technical guidance and the 8-step guide of practical steps for employers to take in response to the new duty. Last Wednesday, the Equality and Human Rights Commission also published some templates to help employers with compliance with the new positive duty, and those comprise a checklist, an action plan, and a monitoring log. Having looked at those, I'd exercise some caution because they were designed for the hospitality industry, so they may not be directly applicable, but they do have some sort of hints and ideas for how you can comply with the duty. One really simple point to emphasise is the need to keep records of what you've considered and done in line with the duty to produce as evidence if you are in an employment tribunal. So use internal emails and meeting and call notes to create a helpful paper trail to show the steps you've taken and the decisions that you made. I think it's going to be particularly important if you're asked how have you met that duty, to be able to point to the reasons why you've decided to take the steps you did at a particular time, but also what other steps you considered taking but discounted and why you discounted them. And one of the things that is strongly emphasised in the Code of Practice and Guidance is a risk assessment. And this is a really key document because if you haven't undertaken a risk assessment, it's going to be very difficult for you to demonstrate that reasonable steps have been taken to prevent sexual harassment occurring. And the quality of the preparation of that risk assessment is really paramount because it's going to dictate what action is perceived as reasonable. So when you conduct and record your risk assessment, write down in the document the steps you took to evaluate the risk of sexual harassment, as well as setting out the risks that you've identified. And that evaluation might involve, for example, consulting with D&I and other workplace committees. It may be obtaining feedback about risks from your senior leadership team. You might want to analyse grievances or whistleblowing reports and exit interviews. And another step you can think about is asking for anonymous feedback through a staff survey about where the risk areas might be. But once you've created that assessment, it's got to be considered a living document. When complaints arise, you need to really go back and reassess your risks, identify if there are risks you hadn't spotted, and think about whether your assessment needs to be updated. And of course, it will be important that you give responsibilities for someone to do this, and for that person to record when an assessment has been updated so you can show its development and how you've responded to issues that have arisen. I think another thing to think about is if you have significant business changes to your workforce, like the acquisition of a new team or a new business, you need to pull out that risk assessment and stress test it and see if there's any changes that need to be made. The next thing you need to consider is the policy wording that you have. And you need to be able to demonstrate that you have an effective policy. Now, the Equality and Human Rights Guidance says you can have a separate policy that just deals with sexual harassment, or you can have one which deals with all forms of sexual harassment. But either way, you need to check through the technical guidance to make sure that what's in your policy includes all the points that that guidance points to as being a good anti-harassment policy. So there are various factors. Also have a look at the 8 steps guidance as well when you're doing that. I think it's going to be really important that you keep your policy and approach really flexible, because the way that you will need to deal with a report of sexual harassment is going to vary depending on the particular situation. So in some circumstances, of course, sexual harassment can amount to criminal conduct. And if that's reported to the police, it may take some time and you may be quite constrained in how you handle the complaint. So we advocate very much a principle-based approach, avoiding too many kind of promises about exactly how long it's going to take to deal with the matter. One of the things that we suggest you consider is asking for employees to check off and sign off that they have read and understood the policy. Now, that can of course, be quite challenging, and not everyone will do it. But bear in mind that you may be challenged in a tribunal situation on whether you can say that you took enough steps to ensure that everyone in the organisation understood the policy and what was expected of them if they didn't. So maybe consider doing that either if you were launching a new policy, or maybe when you do pay reviews and bonuses each year, which is often a good time to introduce new contractual changes or policies. If I could have the next slide, please. Now, as we would expect, training is one of the key things that you're going to need to think of, and which the guidance suggests you undertake. But it's got to be effective, it's got to be meaningful and engaging. And what is effective may vary for different workforces, different parts of your business. So if you have a low risk workplace, then it may be sufficient to do online training. But if you've got higher risk workplace, then it may be appropriate to do in-person training because it may be more impactful. And certainly if you have situations where complaints have been made, you may want to do one-to-one training with individuals about their behaviour. But I think it will be really important to show the modules that you've used, and you would bring those in evidence. So ensure that the examples that are covered are relevant to your particular business. Also consider how you test the effectiveness of that training. So many online training courses have quizzes at the end. If you have one-to-one or in-person meetings, maybe ask people to kind of feedback to you what they learned from the session. And it goes without saying that this training should be compulsory. So you're going to have to follow up with non-attendees, as well as making sure that you do that training regularly. This isn't a case of just doing it now and then not bothering until a situation arises when you feel you should. One other thing that I think is really important is to review and assess the effectiveness of reporting and complaint handling within your organisation. I think you don't take too much comfort if you don't have many complaints, because that's not necessarily a sign that there are no issues or risks. It may be a sign that staff don't feel they have the psychological safety to speak up, or that they're not sure how to speak up in a safe way. And you might want to test that through staff engagement surveys. And one thing that I've discussed with one client is a sort of mystery shopper approach, where you test your processes by having somebody make a complaint and they can feed back on how their experience and how it was handled and how they were made to feel through the process. One thing that crops up quite a lot is overcomplicated processes, which can put people off. Now, reporting and kind of whistleblowing, speaking up in regulated environments, it's quite a complicated set of rules and regulations about protection, etc. But make it as simple as you possibly can, and then the organisation can triage the complaints in the right way once they've been received. I think it's also important, I think many organisations already do this, but think how you can facilitate anonymous reporting. It's obviously difficult to investigate thoroughly and properly if you don't know who's bringing the complaint, but if you don't have anonymous reporting, you might be missing the opportunity to identify issues and risks. And keeping centralised records of concerns which have been raised is going to be important, because then you can identify trends. So you may get one report and think, well, just keep an eye on that area. Suddenly you get more, then maybe you need to give a particular team a bit of focus. And finally, the guidance by the Equality and Human Rights Commission emphasises the need for you to regularly evaluate the effectiveness of the steps that you do put in place, and to implement any changes arising from that. And it actually states explicitly that this will help you comply with the preventative duty. So a big clue there that this is something that they expect you to undertake. So I think what that means is that you need to carry out regular review of complaints data to identify trends and particular issues. Again, kind of think about staff surveys on their experience. And actually, one thing you can do is to ask the victims what could have been done better on reflection when you get to the end of a process. And certainly thinking about lessons learned sessions once after complaints are resolved, maybe with your HR team who've been working on the response to a complaint. If I could have the next slide, please. Thank you. So just a few pitfalls to highlight that you might want to consider. The first of those is don't avoid and dodge difficult or awkward topics of conversation, particularly with senior people. The big personalities and senior staff are not exempt from understanding the organisation's policy or from the requirements. So it will be really important to ensure that everybody in the organisation knows, for example, that retaliation as a result of genuine concerns being raised is entirely unacceptable, and that nobody is exempt from any disciplinary action. I think it's helpful to timetable regular updates, as I've said, but also, as I've said, if issues do arise within the workplace, don't postpone changes to the risk assessment or policy wording or other actions simply because you're waiting for the next scheduled annual review date. You need to be seen to be quite responsive to things that are going on within the workplace. And I also think that to meet the new duty, you really need to think about making a noise about this with your staff and giving it focus and emphasis. I think it is tempting, of course, where there's a fear of an increase in complaints, you know, to just kind of carry on as you are, introduce your policy so it's sitting on the internet. But that might result in being more vocal about it, might result in some short-term pain with more reports, but the long-term gain is an opportunity to address issues and make things better in the future. Data protection and security concerns, obviously, where you've got information, you're reviewing information, just be mindful if you're reviewing previous complaints, etc., to make sure you're anonymizing people's names, etc., to protect protect them and make sure you're compliant with the GDPR. And finally, one risk, of course, is that you think you've taken the right steps, but you get to the employment tribunal and they think you could have done better. I think any employment lawyer will tell you that sometimes the employment tribunal finds it very easy to say with hindsight what you should have done. The difficulty is, as we said, we don't know, we don't have a prescribed list of what exactly you are supposed to do. We're all learning here. So, but I think the lesson here is, you know, do what you can, take it seriously. The more you do, the less risk you will have that you'll get the full 25% uplift, and also keep things under review. And when we start to get cases in, and learn from peers. So, you know, we've been talking about potentially holding roundtable sessions so that we can facilitate conversations with peers so that we can all learn from each other here. And then finally, just when you thought you'd got that all in the bag, although this is a very new duty, it's not even been introduced a month, the Employment Rights Bill proposes an update to it. So rather than the duty being one to take reasonable steps, the threshold will be higher. There will be a duty to take all reasonable steps. We obviously need to wait for expected updated guidance, but it is quite difficult to see how an employer will be able to say they took all reasonable steps if they don't follow the guidance that the Equality and Human Rights Commission has put out. So that is, again, just to emphasise, that's a starting point for looking at what you can do as a business. The Employment Rights Bill also reintroduces liability for employers in cases where employees are harassed by third parties. So that might be clients, visitors, suppliers, or candidates in the course of the employment. And again, where the employer has failed to take all reasonable steps to prevent such harassment. This covers all types of harassment, not just sexual harassment. And it's not just the organisation that might be liable, it could also be individual managers who could be personally liable as they can for discrimination claims at the moment. And you will notice when you look at the guidance that it anticipates this change coming in. It already says and deals with third-party harassment. So this is an issue you need to be looking at now, not waiting for the law to come in. And finally, just one addition is that the Employment Rights Bill confirms that disclosures about sexual harassment will be regarded as protected disclosures. And so somebody who reports sexual harassment will have protection as a whistleblower by default. They don't have to think about the sort of complicated test of whether a whistleblower has taken place. And the government expects that this measure is going to encourage speaking up and reporting sexual harassment, which of course remains to be seen. So that is all I have to say on the new duty. I hope that was a useful run through of the points. I'm now going to hand over to Justin, who'll be talking about the government's other forthcoming employment law reforms. Thank you, Justin.
Thanks, Jo. And as Jo mentioned, this is my first webinar after joining the firm 6 weeks or so ago, and it's a real pleasure to be here. Now, I'm aware that in the last HR webinar, the team gave an overview of the various proposals following the May 2024 pre-election document, the plan to make work pay. And moving on to the next slide, we can see where we are now. So on 10th of October, the Employment Rights Bill was introduced to Parliament, and we also had the publication of the updated policy paper, Next Steps to Make Work Pay, that sets out the new government's mission for employment. So let's talk through the timeline of what happens next. So there'll be consultation on the various changes introduced by the bill, which is required, and these pledges have been live for around a month now. Indeed, the first of these exercises will close on the 2nd and 4th of December, and we'll talk about those in a minute. During the course of 2025, we'll see the bill be presented to the House of Lords for review and any potential amendments prior to the bill being passed. We'll then see consultation on supporting regulations before these are finalised in late 2025, early 2026. So as you can see, we're not anticipating any changes proposed in the bill before 2026. The earliest of which will be April, and the hot topic, the new unfair dismissal rules, will be coming in the autumn of that year. Now, with regards to some of the matters that were excluded from the bill, we also know from the Next Steps to Make Work Pay policy, it's quite a mouthful, paper, that changes to guidance and practice outside of the bill and its supporting regulations will be dealt with separately via existing powers and non-legislative routes. So the following topics are likely to be referenced again in the near future outside of the bill timetabling. And these include things like taking forward the right to switch off, which you may have seen kind of some stuff about in the press, the commitment to tightening the ban on unpaid internships, progressing the commitments on paid travel time, supporting workers with a terminal illness through the Dying to Work Charter, modernising health and safety guidance, a socio-economic duty, and also developing menopause guidance for employers and guidance on health and well-being. So it does remain a case of watch this space in relation to further detail on these matters. But let's have a look at the consultation phase in a bit more detail. So the consultation pledges are still live, but as mentioned, there is a limited window on the following topics: consultation on collective redundancy changes, industrial relations, 0 hours contracts, and fire and rehire restriction close on the 2nd of December. And for SSP, the consultation closes on 4th of December. So now is very much the time to raise points that may impact your business. After the session, we'll circulate the recording of this webinar, and we can provide links to each of the separate consultation papers, so you can go in and have a look at the consultation, look at the kind of questions that are being posed, and you can contribute. In terms of which changes are being proposed in the bill, I'll be discussing SSP in a moment, and David will be exploring the proposed changes on the other topics set out here, save for 0 hours contracts, because I think we're a bit tight for time. So moving on to the next slide, please. So one of the big ones, and the one that has we got the greatest response to in our poll earlier, the change to unfair dismissal law. Firstly, let's have a quick recap of the current position. So, as I'm sure you all know, employees must have at least 2 years service to bring a claim for what we regard as standard unfair dismissal, not automatically unfair dismissal. So those linked to, for example, a whistleblowing claim or linked to taking family leave. There's no required service period for those. The other point to note is that currently there are no specific statutory restrictions on the length or terms of probationary periods, which tend to be contractual. So what's planned? And as you can see from the slide here, the proposals are for under the bill, it will insert a new section of the Employment Rights Act that removes the 2-year qualifying period for ordinary unfair dismissal protection. So unfair dismissal protection will be a day one right. But keeping that in mind, the same section will also provide that an employee must have started to work to bring an unfair dismissal claim. And this avoids a scenario whereby an employee with a contract but who has not yet started work could claim unfair dismissal if they are dismissed before their first day. The bill also introduces another new concept, Whereas probationary periods have always been creatures of contract, they are about to become part of statute. Under the bill, the Secretary of State has the power to modify the unfair dismissal test during the initial period of employment, or IPE. Now, remember that acronym, as it's likely to soon become part of the everyday employment landscape. It's proposed that this statutory probation period, as it were, will set out a new balance for the early months of a job, providing those new legally binding rights for employees from day one, whilst also delivering a lighter touch and less onerous approach for businesses to follow to dismiss someone. These modified standards during the IPE will require employers to show that the reason for dismissal is related to one of the fair reasons, or certainly 4 of them, to employees' conduct, capability, a statutory restriction, or some other substantial reason, which you'll probably know as SOSR, related to the employee. Notably, redundancy is excluded from this list, meaning that employees made redundant during the IPE have the full right to claim unfair dismissal from day one. So the new system will be more onerous for employers in respect of redundancy exercises involving employees with less than 2 years service and attempting to carry out a fair process. What about the length of the IPE? So this is going to be determined in future regulations and is not yet prescribed. The next steps to make work pay paper confirms that the government will consult on the length of the initial statutory probationary period, but its preference is 9 months. And what about the lighter touch dismissal process that we're hearing about? We don't know what that is yet, or what shape it will take, but we know from the policy document that the intention is for the IPE to have meaningful safeguards to provide stability and security for employees. So there is going to be some process in there. Now, thankfully, the government is committing to full consultation on the detail of the proposals. So what do we advise as some preparatory steps? Now, unlike the topics I flagged earlier, the proposed consultation on unfair dismissal is not yet open. Again, a case of watch this space, and once the consultation is open, take the opportunity to confirm the impact of the changes on your business. Working on the basis that the proposals will go ahead without much or heavy amendment, start thinking about the training that will be required to ensure that managers understand the shift that is likely to be on the horizon to manage poor performance and those redundancy situations adequately from day one. Consider your organization's general management mindset and approach when it comes to dismissing employees, perhaps some know-how updates for senior managers and leadership teams that clarify that it will no longer be the case that a process for a standard dismissal for a poor performer or redundancy can be shortcut for individuals with less than 2 years service. Also start to think about the documents you use for performance issues and redundancy exercises post 2 years of service and issues that arise for managers in respect of those, and the issues that arise because those issues are likely to apply to all employees going forward. If your organization tends to rely on facing people issues ahead of the 2-year service requirement to streamline its workforce, you need to start thinking about a longer term approach. And that's particularly the case if you have managers that are based in other jurisdictions where there are lighter requirements to dismiss, such as fire at will from day one. Now, once the new law is passed, policies, procedures, contracts will all need to be updated to reflect the changes. I'd imagine there's going to be particular focus on the IPE, or the statutory probation period. And organizations will need to factor that into their pipeline, both organizational and financial. Okay, moving on to the next slide, please. So now we're going to have a look at some of the other day one rights, and we'll turn first to the subject of flexible working. Now, what's the current position? The right to request flexible working is already a day one right for employees and is irrespective of length of service. Employers must also carry out consultation with employees before refusing a request. So what's the big change? Well, currently it's a subjective test. The employer need only show that they consider that one of the statutory grounds for refusal applies, but the reasonableness of that decision or consideration is not a factor. Now, under the proposed reform, the requirements are modified. employers will only be able to refuse an application if it is reasonable to do so. In notifying an employee that their request has been refused, employers will need to state the grounds relied upon, which is what we have now, but also explain why it is reasonable to refuse the application on that ground or grounds. So we're turning what's currently a subjective test, where the employer only needs to show that they believed one of the listed grounds applied, into an objective test. They need to explain why their decision is reasonable. So again, organizations should start to introduce learning around this shift in the process for decision makers and managers in relation to the higher threshold. The aim of the government was stated as flexible working as the default position. And it's arguable whether or not the proposed changes achieve this, but what is clear is that employers will need to undertake a deeper level of analysis and tangible evidence as to their rationale when attempting to reject a flexible working application. So moving on to the proposed reform of family-related leave. The bill sees parental leave and paternity leave becoming a day one entitlement for all employees. It also removes the current restriction on employees taking paternity leave and pay after they have already taken a period of shared parental leave and pay. Employees will be able to take bereavement leave when anyone dies with whom they've had a specified relationship, and the specified relationship is going to be defined in future regulations. It's also notable that bereavement leave will remain unpaid, as it seems. So some practical steps when thinking about these family-related leave amendments would include administrative and policy changes, and also thinking about wider staff cover and resourcing considerations as well. And finally, SSP. Another matter where administrative changes and financial impact will need to be factored into an organisation's future. As we know, at present, SSP is not paid for the first 3 qualifying days. As such, employees will typically be paid SSP from their 4th day of absence from work. The bill removes the 3-day qualifying period, as well as the requirement to earn the lower earnings limit to qualify. We'll also see a change to the rate of SSP. So more availability for SSP is the message here. And it's been speculated that this may well lead to an increase of days off for ill health, which, when you consider per individual, per quarter, could work out as an expensive business. And on that not so jolly note, I'm very happy now to hand over to David to discuss the proposed employment law reform on fire and rehire, collective consultation, and trade union recognition. Thanks, David.
Thank you, Justin. And just to echo Justin's comments, absolutely wonderful to be here at Fox Williams. This is my first webinar, and I'm very pleased to be speaking to you today. So let's get straight onto it and start by talking about fire and rehire. So the background here is that P&O Ferries fired 786 members of staff and replaced them by much cheaper operators, and that essentially caused a little bit of a scandal, on the back of which the government has chosen to react by proposing to eradicate the mechanism of changing terms, which is by firing staff, terminating their employment, and then offering to rehire them on new terms. Now, that is an interesting change because people who are subject to fire and rehire are protected by the existing unfair dismissal regime. And that regime means that it would be based on some other substantial reason. The courts will look at the upsides for the employer, but also the implications for staff, and it would involve consultation. So what would it mean if this change goes ahead? Well, in order to change terms, which obviously we always need to think about in the context of a modern environment and AI changing the way we work, etc., there are essentially 4 ways. Firstly, you could impose the change, but that would potentially give rise to a breach of contract or even a constructive unfair dismissal claim. Secondly, you could get agreement for the change, but if it is material, the employees are likely to ask for consideration for it. Thirdly, you can rely on your variation provisions in your employment contract. Now, the problem with these is that they are construed narrowly, so the provisions need to be expansive as possible, and that's what employers are likely to focus on with these new changes. And then I suppose the fourth thing is employers just say this is too hard. These employees are too expensive. What we'll do is we'll just do something like a reorganisational redundancy exercise and just move on. So that's perhaps the way that they may think about dealing with it. Let's see how the proposal evolves. Moving on to the next slide. We're really kicking off with industrial relations here. And even if you don't have a union, it really is worth paying attention to this section. So let's start off with the industrial relations landscape. On the chart sets out the number of days lost due to strike action each year since 2010. And as you can see, 3 million days were lost due to strikes in 2023, the last year for which the data is available. This is against the backdrop of 6.4 million employees being trade union members in 2023. That's 22.4% of all employees. It's also worth mentioning that the trade union rights were significantly limited by the Conservative government in 2015. And notwithstanding that, you'll see that there has been an increase in the number of strike days following the coronavirus epidemic. So let's move on to the next slide. What is the proposed changes in this context? Well, firstly, employers will be obliged to provide their employees with a written statement of the right to join a trade union, and to remind them of that right on a periodic basis, which is likely to be every 12 months. As to union recognition, the background here is that recognition can be agreed voluntarily between employers and unions, but when that does not occur, the union can trigger a statutory recognition process. In this context, the bill essentially does four things. Firstly, it replaces the requirement that 10% of the staff in the bargaining unit must be members of a union, and that is replaced with will be replaced with a lower threshold, potentially as low as 2%. The second change is the bill replaces the requirement that 40% of staff in the bargaining unit must vote, and that's going to be replaced with a simple majority of those who do actually turn up and vote. In practice, this is likely to significantly improve the chances of a union gaining recognition. The third change is that where half of the employees in the bargaining unit are members of a union, recognition will be awarded automatically. And the fourth key change is it creates a framework for anti-union practices by an employer, and that those will be outlawed in the context of a recognition application. Now, it remains to be seen what this means in practice, but employers are likely to have to be very careful about what they say about a union that's applying for recognition. Once a union is recognised, then the bill significantly enhances the ability of unions to enter the workplace, to meet, represent, organise and recruit workers to facilitate collective bargaining. This would be backed up by a process whereby the trade unions would make an access request. Employers would then give a response notice within a time frame. The union and employer would then enter into negotiations for a set period, which may result in an access agreement. But if agreement cannot be reached, then the parties can apply to the Central Arbitration Committee, which will determine the content of the access agreement. Once the agreement is in place, if it is breached by either of the parties, then an application can be made to the Central Arbitration Committee, which would then be able to impose penalties. Okay, so we've got recognition, we've got an access agreement. The trade union may then start to think about some sort of industrial action, such as a strike. And in respect of industrial action, the bill introduces 5 key changes. Firstly, it replaces the requirement that industrial action is supported by 50% of staff who make up the collective bargaining unit. And again, that will be replaced by a simple majority of those who actually turn up and vote. And again, people who turn up and vote tend to be motivated to vote for the strike. And again, this will make it much easier for unions to gain approval for industrial action. Secondly, The bill reduces the length of notice that unions need to give employers of planned industrial action from 14 to 7 days, thus giving employers much less time to react. The third change is that the bill extends the period over which industrial action may be taken from 6 to 12 months, which increases the potential impact of the industrial action and therefore significantly increases the negotiating power of the union if industrial action is sanctioned. The fourth key change is that the bill significantly enhances protection offered to staff who are involved in industrial action. And the final key change is that the bill removes the minimum service requirements that can be applied to strikes in certain industries such as transport. Although the important point to bear in mind here is that those rights introduced by the Conservatives have never been relied upon. So let's move on to the next slide. What are the other changes that have been proposed in the collective forum? Well, let's start with collective redundancies. Currently, an employer must consult collectively with appropriate workforce representatives in cases where 20 or more redundancies are proposed within a period of 90 days at one establishment. Now, the bill proposes to remove the reference to one establishment. Now, this amendment was prompted by the closure of Woolworths in 2011, following which it was held that each branch on its own was an establishment, so the duty to consult only applied where 20 or more employees were dismissed at that particular branch. The change has therefore been welcome in many quarters, but there are potentially some unintended consequences. So first of all, an employer with lots of bases in different parts of the country may inadvertently trigger the obligation to consult if one base in the north and one base in the south aren't talking to each other. By the same token, if the obligation is triggered by such a redundancy exercise involving people in the far north and far south of the country, the representatives at one site might not be interested in the exercise at the other. And there's also a risk that for larger organisations, employers will appoint some sort of standing representative body to cover potential redundancy exercises, which could potentially result in essentially meaningless collective consultation. Moving on, as to public sector outsourcing, the bill proposes a guarantee that transferring workers who transfer from the government to a private contractor can essentially cherry pick the best terms from the government and the supplier. And along similar lines, the bill proposes the establishment of a body that will essentially dictate remuneration and other terms of employment for those employed in social care, not only social care. And these will be called fair pay agreements. Now, the interesting thing here is that this is the first time that such a body it would be established in the UK, although similar bodies exist in Europe, and in particular Germany and Italy. It's important to note that although this is limited to social care, it is believed that this concept could be expanded to other industries, such as potentially technology or people building cars and that sort of thing. So it's very important to watch this space. So the final change that I wanted to mention in the collective arena is the bill will repeal the requirement that trade union members must opt in to making contributions to a union's political fund. And instead, the position is that they will be required to opt out. And that's likely to mean that much more of the trade union funds flow into political bodies. So, in summary, therefore, the bill will do the following. It will oblige employers to promote union membership. It will make it easier for unions to gain recognition. It will significantly enhance union rights once recognition is granted. It will make it easier for unions to arrange industrial action. It will expand the protection of staff taking part in industrial action. And finally, it will make it easier for union funds to be diverted for political purposes. So on that note, I'm going to hand back over to Jo for the question and answer session.
Thank you very much, David, and also Justin. Please do pop up your questions. We've had a few on the screen. I'm going to start with you, David, if I may. One question, if a firm doesn't have a recognised trade union, is there still an obligation to engage with staff as part of these trade union rights?
So yes, well, all these rights tend to be about a union being recognised. So what's likely to happen if you don't have a trade union, then there is an enhanced risk that some staff will apply for a vote, and a vote will take place. And if that's the case, then the thresholds for recognition to occur are lower. So it's much likely to occur in your business. Of course, you know, it may be that you don't have a union and you just have a staff body, and that is absolutely fine, and you can continue talking to your staff body. It's only if a union comes along and wants to exercise these rights that they become much more relevant.
And David, do you think that organisations perhaps who don't have union recognition at the moment, should they be sort of embracing this kind of concept of more collective consultation generally within their workforce, because this is the way of the future, or should they be fighting it?
I think bearing in mind that we had 3 million strike days over the last few years, and that there is a rise of the trade unions, you know, and industrial action, I think employers do need to prepare. And I think there's two things you can do. I think you can say, actually, we're going to welcome these reforms, and we're going to welcome a union, and we're going to prepare for that, and we're going to go down that road. The other thing that employers may want to do is to say, we're not so sure about that, but maybe one thing we'll think about is having a staff body with teeth, a staff body that actually represents people, who comes to all the meetings and actually can make a difference. And we suspect that some employers may be thinking along those lines to perhaps head off the changes. Now, if you want to do that, you've only got a year to put that sort of mechanism in place. That's not a long period of time. So it's something that you need to think about in the short term.
Brilliant, thanks, David. And a question for you, Justin. Are you experiencing, and maybe David can also chip in on this, and I can too, but are businesses already sort of in anticipation of the day one unfair dismissal rights, making changes or planning changes to their workforce in terms of getting rid of poor performers kind of early doors when they get to the 2 years before that change comes in?
I don't think, no action as yet, but I think it's inevitable, in particular in relation to redundancy. So if larger organizations go through rounds of kind of riff rounds effectively, then I can see that there will be a move to pull forward such reduction in staff processes to ensure that they're getting in before 2026, autumn 2026, when the new unfair dismissal rights will have teeth. It'll be interesting to see. I'm assuming there will be no reaction from the government about that, but I'd be interested to see what the commentary will be if people do start kind of throwing people out of the door as quickly as they possibly can. But I think the main focus will be on redundancy rounds and kind of reducing staff. I can see that happening.
And just to echo some of those thoughts, we're also seeing some employers start to tightening up their recruitment process. So, you know, be much more diligent on CVs and checking out the information that's provided to make sure that you really are getting the staff you need, and that the reference match the qualities that they're expressing in their interviews.
Yeah, and that's certainly my experience as well, David, to advising clients around that sort of area. And I think there were some clients who were keeping a very close eye on sort of potential timetabling, because they were thinking they might need to move quickly. So I did have clients who were looking around their workforce in anticipation that this right might be coming in before it's now proposed it will come in. So yeah, but definitely some sort of planning ahead, as it were. Justin, automatic unfair dismissal rights, are they changing at all?
No, same position. Whereas the ordinary unfair dismissal rights are going to kick in from day one, automatic unfair dismissal rights, the rules around automatic unfair dismissal, i.e. no requirement for service, etc., and they can be brought as soon as the employee has a contract. There is no requirement for them to start work. They will be remaining the same.
Brilliant. Question just popped in just now, one for you, I think, Justin, as well. Can you clarify the change in flexible working requests? What will concretely change for employers?
So it's this move from whether you can call it concrete or not, but it's and how it's interpreted, we'll see once the right kicks in, and then we see claims, etc., and we'll see a development of case law around the matter, I'd imagine. But the main change is, rather than now just using one of the prescribed reasons for declining a request, you now have to demonstrate why your decision was reasonable. There's no requirement for that at the moment. You can just say, well, for one of those reasons or a couple of those reasons, this is the reason why we've come to our decision. It's based on these prescribed, one of these or two of these or three of these prescribed reasons. Now you'll have to justify your reasoning, and your reasoning will have to be reasonable. So it doesn't sound like a lot, but there will have to be some thinking going into it. And often, the prescribed reasons are completely justified, and you would be able to set out why your thought process in relation to relying on one of those prescribed reasons is appropriate and reasonable. But there will be a bit of thinking around it, I think.
Yeah, I think it's about your paper trail, isn't it, and explaining your reasons clearly in any correspondence that you have. So I think a bit more kind of rigor and work around that and decision making, rather than just sort of kind of short statements that don't really get to the meat of why the refusal has been made. And I think it's also important to say that those reasons why you can turn down a flexible working request will remain the same. So it is, as Justin said, it's a bit of a misnomer to say it's the default that people will work flexibly. I think that caused quite a lot of kerfuffle, but that's not the case, not going to be the case. It's just a sort of bit more rigor around it. I had one question for me. Have we got a sense of when the updated guidance is expected from the Equality and Human Rights Commission? The answer to that is no. Notably, they only updated their guidance on the rules that came into play in October, about a week or so before the rules came into effect. So the rules came in, but nobody really knew exactly what was going to be expected. So if form is followed, it won't be until just before the law actually comes into play. But having updated the guidance to date, and in some ways anticipating some of the changes that are now proposed, because these were things that the Labour government was fighting for as the bill went through Parliament. So we kind of knew where the direction of travel was. It may be a little bit quicker. We of course hope so, because you need time to make sure that you're complying with your duty by taking all reasonable steps, and you can't do that unless you really know what you're doing. So there is a little bit of uncertainty there. Okay, I think, Justin, this one for you. How would this reasonableness work with return to office policies, in your opinion?
It's a tough one. It's already a tough one, I think. But my view is that if employers can show that they can demonstrate the requirement for individuals to return back to the workplace, and I don't necessarily think that has to be tangible. I think if it's reasonable, then, and again, this is new territory, so we haven't seen any opinion from employment judges in tribunals, etc., as yet. But I think if you've got a reasonable argument to say that individuals coming back to work, will benefit, for example, in a law firm, learning by osmosis, and in lots of other businesses as well, is a really key point to individuals being in the office, then I can see that could be perceived as a reasonable reason as to why the business would want and be able to justify why they'd want individuals back into the office, and it would support one of the prescribed reasons. So, I mean, this could be famous last words. I don't necessarily think people need to go out and kind of get metrics on, kind of how individuals returning to the office would benefit the business. I think if there is a sensible and reasonable argument to justify it, then I think that would support it.
Yeah, but if you do have access to statistics and you do have some data around how these things are impacting your workforce, then that is all to the good as well. So if you can actually point to where your business is being affected because people, for example, are not kind of working in the office or are working part-time or whatever it may be, then that's all going to help. But how far you need to go is, as Justin said, a little unclear. I think in terms of your policy itself on flexible working, probably doesn't necessarily need much updating, as long as you updated it after the last change in the law, because most of the sort of nuts and bolts, and as I said, the reasons why you can turn down that application are exactly the same. A further question I may have missed is, are barristers considered third parties in terms of harassment risk? Yes, they are, as are solicitors going to barristers' chambers, so they would be considered as a third party risk. Particularly relevant question at the moment because lots of barristers' chambers are putting on lots of entertainment pre-Christmas for solicitors, so always high risk situations. A question, I think, Justin, another one for you. Can you confirm, so statutory sick pay will be from the first day of sickness? Is that right?
Yes, that's right, from day one of sickness.
Yeah. Another question, with the changes in qualifying period to claim unfair dismissal, will there be any changes to the qualifying period for statutory redundancy pay, which is currently 2 years?
No, it's as far as we have seen so far, no changes to the qualification period for statutory redundancy pay. It's a different part of the legislation. What we're dealing with here is day one rights for unfair dismissal. And obviously that impacts redundancy, as we've heard, and also the IPE, or this initial period of employment, the statutory probation period, that also affects redundancy. But qualification for a statutory redundancy payment, no changes there.
Brilliant. Well, I don't have any more questions in the Q&A section. If anyone has a burning question, I'll give you a few seconds to type that in. But otherwise, thank you very much all for joining us today. As I said, we will be keeping you all updated with practical guidance with our HRLaw updates, which will be delivered to your mailbox. Please do let us know if you don't receive these, or if you don't, if any of your colleagues don't do that. And as we said at the beginning, we're now going to pop the poll up again and see if your views have changed. Is it still that unfair dismissal right that you are most concerned about, having listened to the speakers today? So I'll give you a couple of seconds to pop those into the box. Okay, hopefully you'll have made your choices. So Bailey, can we see the results of the poll? Okay, slight change. I think everybody a bit more worried about sexual harassment prevention and trade unions. And
yeah, the trade union rights has come up as well.
Yes, yeah, and I think that is different. One of the things we have been talking about, as David said, is that these are things that might impact in a way that they've never impacted sort of private businesses before. So certainly one thing that this is really helpful for us to know what you need to know, what you want us to be advising you on these webinars and in HRLaw. So thank you for doing that. So we'll sign off now. I hope everyone has a good day. I hope it's not snowing too much where you are. We've even had snow in central London. So keep warm and look forward to seeing you in the new year.